that's running, and it is. So I'm going to turn things over to the judges and say, good luck.
Welcome, good afternoon. We are second day of the Nationals. I appreciate that you are facing us with smiles and ready to have fun. When we get into this, we're going to go with question 3, and that's a joke. It's question 2. Okay, good. There we go. Got some laughs. All right, now, my name is Mark Simons. I'm a well-known, famous attorney in the state of Nevada. You might not have heard of me yet, but we'll get through that later. Anyway, I've coached and judged for years. I'm looking forward to hearing what you have to say. My fellow judges will introduce themselves, and then we'll have you introduce yourselves and your coach and your mentors or teachers, and then we'll engage with the question. Thank you.
Hi, I'm Karen Milton from New York. I'm a lawyer by training, and I am currently the Chief of Staff in the Inspector General's Office for the Metropolitan Transportation Authority. That's the state agency that oversees the New York City and greater metropolitan New York transportation system. Prior to that, I was the circuit executive for the Second Circuit, overseeing the 13 federal courts in the states of New York, Vermont, and Connecticut, where we actually spent a lot of time talking about habeas corpus. So I'm delighted to return to the conversation, and I look forward to hearing from you.
My name is Charlie Hinderleiter. I'm the Director of Government Affairs for St. Louis Realtors in St. Louis, Missouri. I can already tell you're kind-hearted people because you gave Judge Simons a pity laugh for that horrible joke. I'm a professional political nerd, a past political science professor, and was once a student in the We the People program, so was on the other side of the screen table. I don't know what metaphor to use anymore. But I was once sitting where you are, and I'm looking forward to some 12 minutes of fun as we have this conversation.
Please introduce yourselves and your coach or teacher.
Good afternoon, judges. My name is Brianna Salas. In addition to We the People, I have been enrolled in JROTC and have been the Special Projects Officer at our school for 2 years in a row.
Hello, judges. My name is Laura Ann Moore, and outside of We the People, I am a competitive equestrian. Next year, I will be attending the University of the South in Tennessee.
Hello, judges. I'm Christian Schmenk, and after high school, I intend on going to Howard University for political science and literature, and we're joined today by our instructor, Milton Himes, and our coaches, Amy Henderson Seitz, Michaela Tonking, Ashley Nickel, and Milton Himes Sr.
Thank you. I'll read question 2. While I'm doing, take a deep breath, get ready, and then begin at your leisure when we conclude. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government?
As Chief Justice Salmon Chase stated, great writ of habeas corpus has been for centuries esteemed the best and only sufficient defense of personal freedom. The writ of habeas corpus is the procedural right of an accused person to question the legality of their detention. Habeas corpus is one of the oldest limitations on government, codified in Clause 39 of the Magna Carta.
The writ of habeas corpus is an absolute necessity for limited government because it is a protection of the people's fundamental rights of life and liberty against tyrannical ambition, and it ensures due process. Alexander Hamilton wrote in Federalist 84, "The practice of arbitrary imprisonments have been, in all ages, the favorite and most formidable instrument of tyranny." The writ protects accused persons from abuses of power by authority figures, serving as a check on the government by the people.
The writ of habeas corpus in the United States first expanded and then narrowed in scope. It is the sole privilege written in the body of the Constitution. Article 1, Section 9 provides that the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. It is a fundamental check on the congressional and executive authority.
The Judiciary Act of 1789 expands the privilege, granting federal courts jurisdiction to hear habeas corpus cases. Ex parte Milligan in 1866 prohibited trying citizens in a military tribunal jurisdiction when civilian courts are available. Furthermore, the government's authority expanded to grant habeas corpus in state cases with the Habeas Corpus Act of 1867. However, decisions by the Berger and Rehnquist courts in Murray v. Carrier and Stone v. Powell narrowed the writ where a violation of constitutional rights occurred.
The first congressional law limiting the writ was the Anti-Terrorism Effective Death Penalty Act of 1996, or the AEDPA. This act put a 1-year time limit on filing for the writ, forces federal courts to default to the decisions of state courts, and limits repetitious claims.
In the early 2000s, the status of the writ overseas was debated. Both the Detainee Treatment Act of 2005 and the Defense Appropriation Act of 2006 ruled that no court shall have jurisdiction to consider habeas corpus for Guantanamo Bay detainees. However, Hamdi v. Rumsfeld, Hamdan v. Rumsfeld, and Bush v. Boumediene all ruled that the writ cannot be suspended overseas.
Although the right of habeas corpus is an inconvenience to the government, it is not an unreasonable burden. However, it is an unreasonable burden on the people.
In 1988, Chief Justice Rehnquist made a committee to study the ways in which habeas corpus burdens the government. The 3 largest burdens they found are unnecessary delay and repetition, the need to make counsel more available, and last-minute litigation. However, the government must deal with these inconveniences for the sake of the common good and the social contract.
The AEDPA also places strict limitations on the writ. According to former federal clerk Nathan Nasrallah, the AEDPA has buried habeas petitioners behind its walls since its creation. In our home state of Nevada, the restrictions on habeas are even stricter than the AEDPA, which burdens the people instead of the government.
As the Supreme Court wrote in Bush v. Boumediene, the framers decided that habeas corpus, a right of first importance, must be a part of our framework. Thank you.
So you mentioned that that the writ has been narrowed over in the last several years mostly through court decisions. Let's talk a little bit about the burden on state courts, because usually today, habeas corpus petitions are usually filed by detainees, prisoners in state courts, and then they come up to the federal courts. So the question is, how do you balance it in terms of state court prisoners? I mean, most of there are a lot of habeas corpus petitions that come up to federal court. Very, very few of them are ever granted. So why do you really need habeas corpus? It just seems to be clogging up the court system. What do we do here?
Well, the AEDPA places a 1-year time limit, but in other states, like Nevada, has a stricter time limit. And all prisoners have to exhaust all their options before being able to have their petition heard at the federal level, which with time limits can be very burdensome on the petitioner.
I think a way that we can limit these petitions and make sure that the state courts don't get clogged up is making sure that counsel is available to these prisoners. So for example, most of the habeas corpus filed in state courts is pro se, so by the prisoner themselves. And I think that if we made it so that each person had legal advice through their whole sentencing process, they could consult a lawyer before filing these habeas petitions on behalf of themselves and really understand the likelihood of them getting their petition granted.
And to address the second part of your point, political writer William Blackstone once said that the writ of habeas corpus is the most celebrated writ in England, and I think that carries over to the United States because it offers a very good way of a person, it's a vehicle for a person to actually get their due process. And this restrictions post AEDPA from state to state is a burden that the states should have to deal with. However, it's more burdensome on the people, as we mentioned, because, for example, Texas only has a 180-day turnover for someone's habeas petition to actually expire, while California doesn't have one. So some states are burdening themselves whilst others aren't, but ultimately it's a burden on the people.
I'm going to follow up on that. I don't know that I'm following your argument. How is habeas corpus, that writ, a burden on individual citizens?
Under the AEDPA, it makes it very hard, and especially with rulings such as Fay v. Noya, it's very hard for a citizen to actually get their case fairly heard, because I believe it violates the Sixth Amendment for a right to fair trial from state to state due to the fact that there's such large variance of habeas stringencies, like I said, in the aforementioned Texas and California, which is very exhausting financially and time-wise for the citizen.
And additionally, we can look overseas even to see how burdensome habeas corpus can be. When the decisions of Johnson v. Eisentrager, it declares that any non-resident alien combatant has no access to courts during wartime, which means they have no grant of habeas corpus. And with the Joint Resolution Act, which declares that any American citizen can be declared an enemy combatant, and then the Military Commissions Act, which grants the executive the power to determine when a citizen is declared, to call a citizen an enemy combatant. This places so many burdens on a person's overseas, and especially with like how Guantanamo was treated. And the solution to this would be extending habeas corpus to to any person under military jurisdiction. So that would be a solution to the burdens.
Quick follow-up, does that include prisoners of war?
Sorry, could you repeat that? It cut out, sorry.
Would you include prisoners of war under that in addition to enemy combatants?
I would extend it to prisoners of war, because in Johnson v. Eisentrager, they were German war prisoners that were being held in China, and I would extend it to them as well. I think that under the 14th Amendment, all persons deserve protections of their rights.
Do we need to put such an emphasis on habeas corpus, because there's other protections in the Bill of Rights and other amendments and other language in the Constitution, so that shouldn't we have the ability to be more flexible with suspending or revoking the right of habeas corpus to we'll say non-citizens? If you agree or disagree, let me know.
To address your first point, absolutely not. Habeas corpus has been a vehicle, especially in the past 5 decades, to actually implement the Bill of Rights and actually establish them. Like, we can look especially to the Sixth Amendment with Gideon v. Wainwright, right to counsel, Strawder v. West Virginia, Swain v. Alabama, as well as Batson v. Kentucky in regards to juries, that people are still treated unfairly, and that it should be a much stronger and more central right to protect these people if the Bill of Rights isn't sufficient.
And we could see in our history problems with flexibility of the suspension, especially in Civil War time when Lincoln suspended habeas corpus. In Ex parte Merriman, the Taney Court did determine that it was unconstitutional, and the executive does not have the power. So I think we should make this a really focus on giving this power to just Congress, just like how the Habeas Corpus Act of 1863 did.
And one way that we can another solution to this of trying to balance the rights of the Bill of Rights and habeas corpus is something that Spain, the Philippines, and many Southern American countries employ, which is called the writ of amparo. And this is a sort of similar thing to the writ of habeas corpus, except it includes the bills of rights in this writ, and it makes it so that once the government violates it, they can take the government to court over things such as the right of privacy, which would, for us, would be the Fourth Amendment, and their bills of rights as well.
So let's talk a little bit about, you said that Lincoln was not justified in suspending the writ in 1863. Under what circumstances would an executive be justified in suspending the writ of habeas corpus, especially today, in today's political climate?
I would argue that the executive never has the power to suspend the writ of habeas corpus. As Article 9, as it is stated in the Constitution, it is the power of Congress to do so, and Congress can do this under martial law, as has happened previously with the bombing of Pearl Harbor and the suspension of habeas corpus in Hawaii.
Furthermore, in today's political climate, the exclusionary clause of rebellion may also extend down to insurrections, because the last time there was actually an invasion or rebellion, it was the Civil War and World War II that fit that rebellion clause, because there was a declaration of war at that point. However, I think like we can also look to the January 6th riots, where the writ was suspended later after the ex post facto, if you will, to extend to these people.
All right, it's time. Good job. Yay. All right, it's feedback time.
Well, great job. I mean, difficult, technical area of the law, and you guys had a really good grasp of the issues. I loved your opening. I thought you had a very good, nicely prepared opening statement. You really walked us through it. That habeas corpus, great opening quote, best and only defense of freedom. Really kind of captured, for us where you were going, and then you walked us all the way through to EDPA and to Guantanamo. So I thought, and I loved also that it's an inconvenience, but not unreasonable. That's just a great phrase. Really, really, really just summed it up. I would love to have kept talking to you about Lincoln, justified, not justified, sort of whether or not, but I thought you had some really good answers to our questions. So congratulations. It was a privilege to spend the time with you.
We need like another 8 minutes. I got a lot more questions that I did not get to. You guys took an interesting approach to this. I really liked your prepared statement. As my colleague mentioned, you guys really, I thought, organized that well, and get inconvenience, not a burden, was awesome. We only get to hear that once, so having it well organized, well laid out, I think is really important, and you guys did that very well. In the follow-ups, one minor critique is you're throwing a lot of case law at us, you're throwing a lot of statutes at us. Explain why they're relevant. Instead of like listing 3 or 4, give me one, tell me quickly why it's relevant. Give me another, tell me quickly why it's relevant. That just gives a little bit more strength, I think, to how that backs up and undergirds your argument. I knew most of them, but I'm not an attorney. I don't know all of them. Anyway, you got to explain a little for the political science folks out there. But really, just a great conversation. And man, I just wish we had more time to continue.
Okay, thank you. I want to cover a couple of topics, but after the first 2 go, there's a limited thing. But first off, what I'm drawn is that I love your reference to foreign law, and because that gives us a frame of reference to maybe what we're doing, and we can see where we could go, or where it could go wrong or could go well. I also liked when you were challenged, Christian, on the what's the burdensome nature of this. And you responded, and it was like, don't ever ask me a question again, because I'll bury you in information, and which is exactly what I want to see. But I also, now the overview was, look, you took this a little bit different spin on it, which was hey, look, we understand this concept so well. We're going to flip it a little bit on its head and look at the impact on the individual. You talked about the statute of limitations, the burdens that this person could. So it really, it might be a minor burden because it's a short period of time, and there's so many hurdles that can come up, both in state, and then there's not necessarily so burdensome on the federal government. So I really liked that creativity in taking that angle on the burdensome nature, because most, I'll say all the other teams focused on how the government would look at it. And so it was a great, kind of foil to those types of arguments. Well done. Thank you very much. I really enjoyed it.
All right, good job. I'm going to go ahead and turn off our recording, make sure that's good.